Ready, start. The stringent BCCI constitution limits disqualification to ministers or government servants close only. The same should not be extended to members of parliament or members of the legislative assembly. It is also submitted that in the event sports persons and coaches serve as members of parliament, members of legislative assemblies, or hold other public offices, disqualifying them on grounds of holding public office would create an unjustified restriction on their participation in the administration of the sport as well as contributing to the public. Ministry of Youth Affairs and Sports and state associations have supported the above contentions with state associations suggesting that the provision be revised to provide for disqualification only on the ground of being a minister or government servant. At this juncture, we may note that similar arguments were raised before this court in the BCCI-1 wherein the court discussed and rejected the contentions raised by the BCCI to the effect that bureaucrats and ministers should not be disqualified from holding a position on the board of cricket. In light of the above, we see no compelling reason for us to reject the recommendation which disqualifies ministers and public servants from holding offices in the state associations or BCCI. The contention that favors which BCCI receives will disappear just because a minister or civil servant is not an office bearer in the state association or BCCI has no real basis to commend itself to us. So also the contention that it should be permissible to hold office simultaneously in BCCI and the state association has not commended itself to us. However, when the matter again reached before this court, an amendment was passed by the BCCI which was approved by this court, restricting the disqualification from being a minister or government servant or holding a public office close to being a minister or government servant close. In agreement with the view of BCCI Supra, we are inclined to modify the provision in Article 1.17 G2 being a minister or government servant close. Further, even if such a person is a public servant, if he or she has the necessary approval of the government, there should not be a problem under section 4 (2) of the newly enacted NGSA 2025. The rules and regulations applicable to a government servant provide a particular standard to be maintained. The standard requires the public servant to obtain necessary permissions. If these permissions are taken, perhaps there is no justification to restrict or disqualify a public servant altogether. A suggestion has been made by Mr. Rahul Mehra to amend Article 1.17 (h) to include situations where a person who has served as an office bearer of any NSF shall be disqualified from holding a post in the Federation. This argument is supposedly grounded in the objective to prevent persons from rendering tenure restrictions odious by simply switching to another sport after finishing tenure in one NSF close. In view of the facts, we find that accepting this suggestion might not benefit the Federation and could be too onerous on sports administrators.